Welcome everybody to the third day of the BGIN conference. We had two opening sessions in the mornings, one related to governance, one related to the digital identity, the second one was related to stablecoins, and now there is an important aspect that is opened by blockchains and the things that come around with them, that is legal issues or regulations. How do you are going to regulate these new implementations? And actually, governance was one of the topics that was touched upon yesterday in the first session in the afternoon in the panel. And now we are going to have three sessions, three presentations in the morning that from legal experts that are going to be talking about different aspects on how regulation should go for different aspects of things introduced by blockchains. And one of the most disruptive implementations of blockchains is DAOs. Decentralized autonomous organizations that allow organizations to work autonomously in this environment. And they pose a very important set of legal challenges and regulatory questions, and which is the best setup that abides to the current regulation, something that is very important to understand how to deal with. And it is for me a pleasure then to open the last day of this BGIN block number 6 by introducing Professor Florence Guillaume, who is a full professor of civil and private international law at the Faculty of Law in the University of Neuchâtel in the Romandie, in the French-speaking part of Switzerland. Her research and publications cover a wide array of topics, including international corporate law, international business litigation, international intermediate securities law, national and international succession law, trust disputes, and legal issues of digitalization. And this is where her interest comes from. In 2020, she founded the Lex Tech Institute, which is an academic center dedicated to research and training in digital technologies. Before entering academics, Professor Guillaume practiced as a lawyer at the Geneva Bar and the Zurich Bar. She also worked as the deputy of the head of private international law department at the Swiss Federal Ministry of Justice. Florence, it is a pleasure to welcome you to the conference. Thank you very much.
Thank you very much, Colin. Thank you.
Thanks, Florian.
So good morning to you all. Thank you, Claudio, for the nice invitation to speak today with you about the laws applicable to DAOs. So it's going to be everything about law. I hope I will be understandable. This is a topic that is very complex because it is a legal topic, but it is also very simple since DAOs do not need the law to exist. So in this presentation, I assume that the rules of law must apply to a DAO for some reason. The objective is to determine which legal regime is most appropriate when there is a contact with the real world. But it is clear that DAOs operate in a digital environment and that it, in general, does not need the law to operate. So there are currently very few states that have adopted legal rules for DAOs. In addition, the application of rules of law to DAOs is a topic that is little explored by legal scholars. This means that the legal regime of DAOs is very uncertain for the time being. But this context of lack of national laws has not prevented the constitution of DAOs. On the contrary, many people are interested today in creating DAOs, so much so that it is becoming some kind of a fashion trend. It is therefore important to see how the law reacts to this new type of social organization. I will begin by introducing the notion of DAO from a legal point of view. This first question is at the heart of the legal challenges raised by DAOs. The way in which a lawyer perceives a DAO determines the legal rules that may apply. We will see that DAOs are generally referred to as digital companies. This qualification has several consequences. The most important implication is that the existence of a company necessarily results from the law. Unlike natural persons, a company can only exist if the law grants it a legal existence. If this reasoning is transposed to the DAO, it means that a DAO can only exist if there are legal rules for this form of company. This is obviously a problem since the vast majority of DAOs are created outside of the law. The constitution of a DAO is generally not based on legal rules, but only on a computer code. This is therefore a problem with the recognition of the very existence of a DAO from a legal point of view. In the second part of the presentation, we will see how a DAO that comes into contact with Switzerland can be treated by Swiss law. This happens, for example, when a DAO enters into a contract with a person domiciled in Switzerland. But the main problem arises when you try to apply Swiss law to the DAO itself. The legal situation is unclear, as there is no rule applicable to DAOs in Swiss law. In the third part of the presentation, I will present briefly the main solutions that have been developed in practice to create DAOs in Switzerland. Even if it is not possible to incorporate a DAO under Swiss law, we will see that Swiss law is flexible enough to allow the creation of DAOs in Switzerland. So I will first discuss the notion of DAO. I'm going to take a strictly legal approach without discussing the technical aspects that you certainly know much better than I do. So first, a few words on the evolution of the crypto economy to situate the DAOs in time. We can identify 4 events that have been significant in the history of DAOs. These are the main events, I think. The first milestone is the launch of the Bitcoin blockchain in 2009, which introduced a peer-to-peer payment system. The idea to create a new form of virtual corporation has appeared since the early days of Bitcoin. The original idea was to create a new form of company that would rely on the security, predictability, and speed of computer code. So we were already discussing about something like DAOs in 2009. However, Bitcoin does not support the technology that is needed to create organizational systems complex enough to decentralized entities. Today, the creation of DAOs on Bitcoin is beginning to be possible by using an additional layer implemented on top of Bitcoin. But Bitcoin is not a blockchain of reference for DAOs, as you know. The second milestone is the launch of the Ethereum blockchain in 2015. This blockchain introduced smart contracts complex enough to create DAOs. These digital entities are defined in the Ethereum white paper as long-term smart contracts that contain the assets and encode the bylaws of an entire organization. In other words, DAOs are made up of a network of smart contracts defining their governance rules. What differentiates a DAO from a smart contract is that a DAO has some form of internal organization that defines the governance of the entity and establishes the procedure to manage its crypto assets, while smart contracts are simple rules that execute an operation when determined conditions are met. It is this technological development that is at the origin of the first DAO. The DAO project is the first known example of a DAO in operation. But this project was not mature enough and lasted only a few months in 2016. We can also mention that the launch of the Aragon platform the same year has brought DAOs with everyone's reach by allowing the creation of a DAO in a few clicks. Today, DAOs are a key element in the construction of the Web3. As you know, Web3 is built upon blockchain technology and is characterized by greater decentralization, more privacy, and ownership of one's own data. DAOs are a key element in the development of Web3 and will be widespread in this environment. It is therefore not surprising that there is today a real buzz about DAOs. DAOs can be created and shaped to serve a wide range of purposes. To illustrate this point, existing DAOs can be organized into different categories. You can have, for example, an investment DAO, like the DAO that I mentioned before. You can have also a crowdfunding DAO, like Constitution DAO, maybe you have heard of this DAO, Constitution DAO. It was created in order to buy a unique copy of the American Constitution at an auction that happened last year at Sotheby's. You can also have many other types of DAOs, like you can see on my slide. But I must say that this list is not exhaustive, and many different categories could be added. So it's just some examples of categories. The important takeaway here is that a DAO can take any shape and have any purpose that can be encoded on smart contracts. Now let's have a look at the internal organization of a DAO to determine how this type of entity can be qualified under the law. In some respects, a DAO is very similar to a traditional company. A priori, we can say that a DAO is some kind of a digital company. However, the graphical representation on the slide shows that there is a fundamental difference between a company and a DAO with regard to the organizational structure. The decentralized governance is the main difference between DAOs and traditional forms of companies. This element implies that a DAO does not normally have any internal hierarchy. There are no central bodies, such as a General Assembly or Board of Directors, and no member can represent the DAO without the agreement of the entire community. There is also a significant difference in the rules applicable to the organization of the entity. In a company, the relationships among the members of the company and between the members and the company are ruled by the provisions of company law and the bylaws. In a DAO, the internal relationships are entirely governed by the code. The code defines the governance model of the DAO, how members can contribute to the entity, and the purpose of the DAO. With this respect, it is important to say that a DAO is governed by smart contracts and that it will only be able to perform the operations that are provided for in its code. There are therefore some technical limits to the governance of a DAO. In a company, the limits to the administration of the company are imposed mainly by the law. While keeping in mind these main elements that differentiate DAOs from traditional forms of companies, it can be assumed that a DAO can generally be considered as a company. Assuming that the DAO can be qualified as a company, we can now proceed to the next step by making a categorization of DAOs. There are different ways to categorize DAOs from a legal point of view. We can make a first categorization of DAOs according to their territoriality. From a Swiss point of view, there are two categories of DAOs: domestic DAOs on one side and foreign DAOs on the other side. By domestic DAOs, I mean DAOs that are governed by Swiss law. By foreign DAOs, I mean DAOs that are not governed by Swiss law. Since Swiss law does not provide for the possibility of creating a DAO, there should not be any domestic DAO or any Swiss DAO. This is why I put a question mark in the diagram. All the DAOs that are in Switzerland should therefore be foreign DAOs. We can thus make a first statement that there are foreign DAOs which have activities in Switzerland, as there are foreign companies which conduct business in Switzerland. This leads us to the second categorization of DAOs according to their legality. In Switzerland, this distinction only concerns foreign DAOs because you don't have any Swiss DAO. Among the foreign DAOs, we can distinguish two categories of DAOs. First, there are a few rare DAOs that are incorporated under the law of a state. A few states have actually passed a DAO law. In these states, DAOs are simply a new form of company established by the law. Their legal regime is defined by national law, as it is the case for any type of company. We will refer to these DAOs as regulated DAOs. The second type of DAOs are not created under the law of a state. This is the vast majority of DAOs currently in existence. They are constituted outside the law and do not need the law to exist. Their legal regime is very uncertain because they are international entities, and it is not really possible to link them to a particular state. I will refer to these DAOs as maverick DAOs, but other terms are also used, for example, illegal DAOs, but I will call them maverick DAOs. We can thus make a second statement that among the foreign DAOs which have activities in Switzerland, some are foreign companies regulated by their code and the provisions of company law, the so-called regulated DAOs. And on the other side, we have true DAOs regulated only by their code that we are going to call the maverick DAOs. If you want to incorporate a DAO under the law of a state, so if you want to have a regulated DAO, you have today the choice between 4 different laws around the world. There is only 4 states where the law specifically allows the creation of DAOs. Malta was the first to introduce legislation in 2018, but to my knowledge, no DAO has been created under this legal regime. Probably it was not mature enough to suit the need of the persons who wanted to create DAOs. The US state of Vermont passed legislation also in 2018, introducing the blockchain-based LLC, so-called BBLLC. This is a specific form of limited liability company, which can have its governance carried out on the blockchain. Thanks to its LLC wrap, the DAO has legal personality, which is very important, and enjoys all the rights and obligations of other LLCs. In 2021, the US state of Wyoming adopted a similar legal regime for DAOs by introducing its own DAO LLC legislation. And finally, the US state of Tennessee followed suit in April 2022 by adopting a law that is mostly a copy of Wyoming's bill. Vermont, Wyoming, and Tennessee DAOs benefit from legal regimes that give them the capacity to sue and be sued, to carry on business activities, and to enter into contractual relationships in their own name. This is not the case for DAOs incorporated in Malta, which have no legal personality. A handful of other states have also passed legislation applicable to DAOs. For example, the Marshall Islands modified their Non-Profit Entities Act in 2021 to introduce non-profit DAO LLCs and non-profit DAO corporations. It is also worth noting that the laws of some other states are flexible enough to offer legal wrappers to DAOs without a dedicated DAO legal regime. Such is the case, for example, in the US state of Delaware, where an LLC can be administered via a decentralized application on the blockchain. So it is possible to administer an LLC via a DApp. The DAO laws have allowed the constitution of a few regulated DAO, so very few regulated DAOs, because most of the DAOs in operations are maverick DAOs, which are created outside the law and are governed only by their code. So now that we know what is a DAO, we are going to see what happens legally when a DAO acts in Switzerland. There are different ways in which a DAO can enter into contact with a Swiss legal order. This happens, for example, when a DAO has an employment contract with a developer domiciled in Switzerland. There are also situations where a DAO may have contacts with Swiss authorities, for example, in criminal or tax matters. There may also be members of the DAO who are domiciled in Switzerland and who have financial claims against the DAO or against other DAO members. The legal relationships of a DAO raise rather complex legal issues. But the answer to all the legal problems depends above all on the answer to one fundamental question. Does the DAO have a legal existence in Switzerland? If it does, then other questions can be considered, such as the validity of the employment contract with the developer, or determining who is responsible for the payment of taxes. But if the DAO does not exist in the Swiss legal order, then it is not worth considering other legal issues that might arise. So I'm going to focus on this one question: does the DAO have a legal existence in Switzerland? To answer this question, it is necessary, in theory, to make a distinction between Swiss DAOs and foreign DAOs. A Swiss DAO would be incorporated in Switzerland and would have a legal regime defined by Swiss company law. Swiss law would, for example, determine whether the DAO has legal personality. But since there is no Swiss DAO law, there is no DAO incorporated under Swiss law. It is therefore not very useful to consider the case of a Swiss DAO. However, even if there is no Swiss regulated DAO, there are exceptional situations where Swiss law may be required to apply to a maverick DAO. But this only happens in very special situations. I will thus only consider the case of foreign DAOs. Those are the DAOs that are not governed by Swiss law. And again, we have to make a distinction between regulated DAOs and maverick DAOs. So the DAOs that are regulated by a law and the other DAOs, most of them. If we look at regulated DAOs first, we can treat them in Switzerland as any other kind of foreign company. They are companies, they are registered in the state, their incorporation state, like a company. So we can consider them as a foreign company. And the legal existence of the DAO is recognized in Switzerland if the DAO is validly constituted under the law of the state in which it has been incorporated. So for example, a Vermont BBLLC would legally exist in Switzerland if it has been validly incorporated in the US state of Vermont. Since the Vermont BBLLC is a company with legal personality under Vermont law, its legal personality will be recognized in Switzerland. The DAO will thus be able to act as a company and, for example, have contractual relationship in its own name. Once this has been achieved, it is then possible to examine other legal questions, such as the rights and obligations of the parties to the contractual relationship. The answer to this last question will depend on the law applicable to the contract, which may be either a Swiss law or a foreign law, depending on the situation. We have seen before that DAOs incorporated in some states do not have legal personality. For example, a DAO incorporated under the law of Malta would not have legal personality. Such a DAO could nevertheless be recognized in Switzerland in the same way as another company, but it will not have legal personality in Switzerland either. It would therefore not be able, for example, to sue or to be sued in Switzerland. So as you can see, the question of the legal existence of a foreign regulated DAO does not raise any particular legal issues. It's exactly the same situation as with any other foreign company. But if we are in presence of foreign maverick DAOs, that is to say DAOs that are not constituted under the law of a specific state, DAOs that just exist because of their code, that's of course a majority of DAOs that you can meet today, the situation is much more complicated. Since a maverick DAO is not incorporated under the law of a state, its legal regime is unclear. I must point out in this regard that the law does not in principle apply to a maverick DAO. But the question may arise in some cases, for example, when a member of the DAO raises liability claims against the DAO. In such a case, it is necessary to find out how to legally treat the DAO. There are two ways to treat a maverick DAO. First, one can try to apply substantive law to the DAO. So we directly apply Swiss substantive law to the DAO. Second solution would be to apply Swiss private international law to the DAO. So the two reasonings are quite complicated, and I will try to explain them as simply as possible. If we apply directly Swiss substantive law to a maverick DAO, a qualification must be made to determine whether it is possible to apply to the DAO the rules governing one of the forms of company existing under Swiss law. If the DAO fits into one of the forms of company that we have in Swiss law, we will bring the DAO into it. Swiss legal scholars usually try to apply the rules of the Swiss simple partnership. This means that the DAO is not considered as a company in Switzerland. Since the DAO does not exist as a company, it does not have a legal existence, and it can only act through its members who assume full responsibility. A major drawback of this reasoning is that one and the same DAO will have a different legal regime in each state. For example, a Swiss judge will apply the Swiss Code of Obligations to determine the personal liability of the members of a DAO, but a California judge will apply California law to answer exactly the same question. Since it is impossible that the answer will be the same in the law of every state, the members of a DAO are exposed to legal risks that cannot really be measured, because it depends totally on which court is seized in case of a dispute. So personally, I prefer the second way to legally treat a DAO, which consists in applying the rules of private international law. In this reasoning, a maverick DAO is considered as a foreign company and is recognized in Switzerland under the same conditions that apply to a foreign company. This solution has the advantage of being exactly the same as the one applied to the regulated DAOs that we saw just before. However, this reasoning raises several difficulties, as it can in principle only be applied under two conditions. First, the foreign entity must qualify as a company. This qualification is made under private international law. You see the article on the slide. And you can see that the notion of company is very broad and encompasses all entities that have a social organization. It's not defined by the law more precisely. So we can say that in principle, a maverick DAO will meet the first condition and will qualify as a company. It's sufficiently organized, so we can say that it is an organized entity, so an organized association of persons or an organized unit of assets, and it can fit in this definition. So we can say that it is a company under this provision. So first condition is okay. Now let's move to the second condition. Second conditions to recognize the DAO as a foreign entity is that the foreign entity must be validly constituted according to the law under which it is organized. Or following that, according to the law of the state where it is actually administered. Okay, so now we have a problem because a maverick DAO cannot meet this condition. Indeed, the maverick DAO cannot be validly constituted under national law, since by definition, such a DAO is not constituted under any law. The organization of a maverick DAO is governed by its code, not national law. The backup rule, which connects the company to its place of administration, is not appropriate for a maverick DAO either. It is not possible to link the administration of a DAO to physical space, because the only place of administration is a digital space. Therefore, a maverick DAO cannot be recognized in Switzerland as a foreign company, insofar as it is not possible to determine if it has been validly constituted according to a foreign national law. In other words, the application of private international law rules leads to a solution where maverick DAOs do not exist in the Swiss legal order. This means that it can only act through its members who assume full responsibility. So finally, if you have been paying close enough attention, you have noticed that the solution is the same regardless of the reasoning. The answer to the question whether maverick DAO can be considered as a separate company from its members is always negative in Switzerland. Thus, the legal existence of a maverick DAO as a company cannot yet be recognized in the present state of Swiss law. But it must be said that the problem is exactly the same abroad, and that, to my knowledge, no state has settled this issue to date. So it's exactly the same problem everywhere. The fact that the DAO is not a separate legal entity from its members and cannot act on its own behalf has consequences for its legal relationships with its members or with third parties. For example, each member of the DAO could be deemed to be jointly and severally liable for the debts contracted by the DAO. At this point of the presentation, the legal treatment of DAOs in Switzerland can be summarized by saying that there is no Swiss DAO law, which prevents the creation of a DAO under Swiss law. There is thus no Swiss regulated DAO. Second, DAOs that come into contact with Switzerland can be treated in the same way as foreign companies. This means that foreign regulated DAOs, which have been validly created under a foreign national law, allowing the incorporation of DAOs, have a legal existence in Switzerland. However, maverick DAOs, which are only governed by their code, don't have a legal existence in Switzerland. They cannot be recognized in Switzerland as foreign companies. So now we can ask ourselves, what should the members of a maverick DAO do if they want to act in Switzerland to conduct business? I will present very briefly 3 solutions that are currently applied without going into details. The objective is just to show that Swiss law is flexible enough to use a DAO in the Swiss legal order, even if it is not possible to create a DAO regulated by Swiss law. So the first and simplest solution is to use an agent to represent the DAO in the real world. The agent can, for example, compensate for the lack of legal personality of the DAO by representing the DAO in signing contracts with third parties. However, it should be noted that the legal position of the agent is unclear and that he may have personal liability. But it's the easiest way to represent the DAO in the real world if it wants to have contracts with third party, for example. Second solution, developed by Swiss entrepreneurs and lawyers, is to incorporate a DAO into a Swiss association. In this model, the association is represented by the management committee, which executes the decisions of the DAO. The DAO is the body of the association and can have specific powers. For example, the power to elect the committee, to propose projects, to vote on proposals, and to vote on the use of the funds of the association. The third solution that could be used to conduct business in Switzerland with a DAO is to incorporate a DAO into a Swiss foundation. In this model, the foundation board represents the foundation and executes the decisions made by the DAO, which is the body of the foundation. The powers of the DAO are basically the same as if it were incorporated into an association, but the rules of law applicable to the foundation are very different from those applicable to the association. It must also be said that the use of a foundation is much more expensive than the use of an association. So these are the 3 models that are used today to use a DAO in Switzerland. Some people say to make a Swiss DAO, but it's just to use a DAO in Switzerland because you are not making a DAO under Swiss law. You are using a maverick DAO and trying to find a solution to make it be represented when it has to enter into contractual relationships with other parties or to speak with the authorities, etc. So it's just ways to materialize the DAO in Switzerland to help it have contact with other people or with the authorities. So these 3 models show that a DAO can be integrated into the legal structure in Switzerland, but it must be kept in mind that the solutions that are applied in practice to create DAOs in Switzerland are still experimental. We do not have enough experience to evaluate the real implications of the different existing models. As long as the Swiss legislator has not adopted a DAO law, the legal situation is very uncertain. In any case, like I said, it cannot be regulated DAOs because we don't have a DAO law in Switzerland. it should be only a Maverick DAO, and it is used in another structure, in another legal structure. So I'm already at the conclusion. In conclusion, we can state that DAOs can be used in the same way as companies to carry out different types of projects, whether they are social, charitable, cultural, or business-oriented. Compared to traditional companies, DAOs can be created more quickly. The governance of DAOs can also be defined more freely and be tailor-made in order to integrate governance structures adapted for each project. In addition, DAOs can very easily bring together people around the world who can actively participate in their governance. However, from a legal point of view, it is still a risky endeavor to initiate a project in the form of a DAO or to join one today. With the exception of Malta, Vermont, Wyoming, Tennessee, and a few other states, legislators have not yet taken an interest in DAOs and have not defined a legal framework for this type of entity. So even the DAOs regulated by national law, the regulated DAOs, have an unclear legal regime in other states than the ones in which they have been incorporated. So their regime is clear only in one state, the one in which they are incorporated. Anyway, the vast majority of DAOs are not regulated by national law. Since no state offers a legal regime to DAOs created outside of the law, the Maverick DAOs, their legal regime is very uncertain. One can even say that it is a completely non-existent legal regime. Given the legal uncertainty, what is the future of DAOs? For sure, DAOs will not replace traditional companies, but rather offer new alternatives to existing corporate and social organizations. However, the choice to create a DAO involves being able to assess whether a digital governance structure makes sense for the type of venture you wish to undertake, and whether it is adapted for the stakeholders. The future of DAOs will be greatly influenced by legislation and how DAOs will be treated legally. In Switzerland, entrepreneurs and lawyers have explored different ways for creating Swiss DAOs, mainly by using an agent or by incorporating the DAO as a body in a foundation or in an association. Another solution would be to adopt a Swiss DAO law. If this way would be considered, we could imagine to follow the American model and create a new form of company like a DAO GmbH, so a DAO Société à responsabilité limitée, DAO LLC à la mode suisse. In any case, any legal framework must comply with the expectations of the people who want to use a DAO. This is probably the most important thing. Furthermore, one must be aware of the fact that there is no uniform legal regime for DAOs. And that is inevitable, that they are treated differently by the laws of the various states. I have presented you the way DAOs are treated in Switzerland, but each country follows its own way to deal with DAOs. So there is still a great legal uncertainty. So I'm at the end of this presentation. Thank you very much for your attention. Thank you.
Thank you very much. And to start the questions, the representative from Wyoming was the first one to raise his hand.
So I'm very interested to hear you about the Wyoming deal.
Fantastic presentation. Thank you for that. I'm not a legal scholar by any means, so take my comments with a grain of salt. My understanding, limited albeit, of all legal systems is that it's always about liability, where the boundary of liability lies, right? Whether it's at the firm level or passes to the individual who forms the entity. And it all comes from the British experiment with this. The corporations came about because the wealth of aristocracy has been plundered. So I would wonder if the final solution to this prerogative, if it exists, it comes when there is mass bankruptcy in the DAO world, which then brings about what the potential solution is going to look like. Let's say that there are Maverick DAOs that have contracted with each other, and one fails one sues the other, and now there has to be a resolution of that conflict. If they both are Maverick under a Swiss law, what would be the next step? How this is going to proceed?
Well, that's a very good question, because if in the actual state of the law, Maverick DAOs will not be considered as companies in Switzerland. So there is no legal wrap around them. So there is no wall between the DAO and the people behind the DAO. So if there is some kind of bankruptcy, I don't know if you can say bankruptcy, but a lot of debt, I think that the members of the DAO will be responsible for the debt. So that's the main problem, because you have to identify these people and bring them before the court if necessary. So you have now proceedings in California. I'm sure you have heard about it. It's not exactly the same, because it's a story about a hack, always the same story. And some of the members of some of the investors of the DAOs say that the code was not secure enough. And they sued the DAO, and well, I'm going to call them the core members of the DAO, as the core persons who made the DAO. And they are considering that the DAO is a general partnership. So it's exactly the same thing that a simple partnership in Switzerland, it's exactly the same thing. So they are suing the DAO as a general partnership, and the consequence is that the people behind the DAOs, the core members, are going probably to be considered to be liable if this qualification is a good one. So this is a problem. We don't have the wall between the DAO and the persons behind them.
Fantastic. So what that means is then your entire private wealth is at risk if you are a member of a Maverick DAO. Now, the other thing is the date at which you become liable is also questionable, because it depends on what the infringement date is. I could have sold my stake, my token, and I still can be on the hook because at the time it happened, I was the member.
Yes, that's a problem. Maybe you have just a token for $10 and you are going to be sued for $1 million. That's a risk. That's a risk that you are facing today with this kind of qualification. Because that's why I said that it's very uncertain today. But if you have a Wyoming DAO, it's totally different. But you have to incorporate it as a company and enter into this wrap, and it's totally different. Some people would say that it's not a true DAO.
We will visit you often.
It's a good solution. I think it's a good solution, and it would be probably a good solution for Swiss law to have some kind of Swiss DAO, so that we have a wall between the investors and the company, because you don't have liability, personal liability in this case. Yeah, this is the best system. But there are very, very few regulated DAOs in circulation today, because everyone is doing a DAO, just clicking some things, and everyone has DAO now, but yeah, it's different.
Thank you. Leon, what's next?
Yes, excellent presentation. I wish I had heard it last year when we were setting up a DAO. But you split all the DAOs into regulated DAOs and Maverick DAOs. I think there is a third option.
Okay.
Hopefully it will be as good or maybe better than the first two, which is international private law, and specifically International Chamber of Commerce. They operate under their own legal framework. So as you know, they have their own courts, their own rules, and they're not a national entity. Actually, they are present in pretty much all countries in the world, almost like United Nations. So don't you think that they can become a platform, a legal platform, which will create some sort of framework, legal framework, under which DAOs can be registered, and then they can provide all other legal tools as well, such as courts, for example?
Of course, they could. I don't think they will, but they could. Because to have a company today you have to have legal rules. So that's the law that gives the company its legal existence. And it's the same everywhere. And this law must be a national law. So international organizations, they don't have the power, they don't have the sovereignty to make laws that can give a company legal personality or legal existence for the time being. So this is very strange because you have international bodies like the one you mentioned and other ones. And
they were fantastic.
it should be the best solution for DAO because it's international. DAO is totally international. You cannot anchor DAO in a state. I don't think it's a good solution. So it's international by essence. And the best solution would have to have an international law, like you said, an international platform, something that can give legal existence to this kind of entities. But for the time being, it's not possible. And I don't think that the law can do that because it must be a national law that gives legal existence to the body. That's a difficulty. And we have model law, some kind of, yes, it's a model law, it's Koala model law, which is written in this idea to make an international DAO law to absorb all of the DAOs so that you have an international legal regime that is the same everywhere. But this law must be adopted by each state to be enforced. That's the point. So it will be available only in the states which have adopted it. So I think it must be the same, but it's a very good idea. Do you know any DAO?
You ask the question.
No. Yeah.
Very.
Yes, but this kind of DAOs anyway will have to be recognized in every state, and every state will have to say, okay, I recognize DAOs made under this system. It doesn't help at the end of the day.
There are two more questions that I hope that we can resolve fast. Please, Florian.
Yes, thanks for the presentation. I just have a short question or something that baffles me all the time. So you mentioned DAOs as companies, but I see some difference between companies and DAOs. And theoretically, the difference is that a DAO can exist without people, while for a company, as far as I know, probably it's not possible. Do we see some legal implications of that? Or could it even be that the DAO is a person in some way, like an autonomous entity?
Yes, so I don't know any DAO which is totally autonomous. Does it already exist? I don't know. I know that it is an idea, but does it exist in practice? I don't know. It is the idea to have which is it Wyoming bill? Yes, it's a Wyoming bill that authorizes DAOs to be managed, algorithmically managed. So maybe it's the idea to have an artificial intelligence behind the DAO. I don't know. Or maybe it's only smart contracts, like in the Tennessee bill. They said specifically it's smart contracts, not algorithmically managed. So maybe it's the idea. But I think for the time being, you always have still people behind the DAO. Anyway, so you don't have totally autonomous DAOs living by themselves for the time being, yeah?
Shinichiro asked the last question, and I apologize because it is a very interesting discussion.
Thank you very much. Very interesting presentation. And my question is about that what we discussed yesterday. Yesterday we discussed about the difference between the global and the international. You know that the internet or the permissionless blockchain is a global thing, not international thing. And my question is, do we need to have some common framework or common idea among different nations for regulation or law or toward the DAO? Because that if that Swiss has some regulation or law for the DAO, and but so if that the concept of the law for the DAO is very different from the Switzerland, Japan, and other countries, so it's not easy to handle that DAO internationally. What do you think about that? We need to if we need to have some common framework among different nations for DAO.
Well, it will be the best solution anyway, to have one common legal framework for every DAO, so that they are treated the same way in every country. So this is the idea of the Koala model law that we made. It is supposed to be applicable in every country, but every country has to apply this law, so to implement this law in a way or another in this country, in its legal regime. So this is the only solution for the time being. Any solution would come from an international body, would have to be implemented in the national law of each country. So this is the problem. We still have many countries in this globe. So you cannot have any other solution. You will always have this problem. Or you make something totally independent from the nation states. So you create an international platform above all the nations, and you create a model law for DAOs on this international platform, and you use only this one, but you are disconnected from the states. And it has already been tried for other topics. It has never been implemented, but yes, I hope maybe we can do this for the DAOs. It could be a private international law, it could be substantive law. So it depends on the body, international body that is going to make something, but it will be very complicated.
Thank you very much.
Thank you, Junichiro, for the question. Thank you, Florence,
Thank
for
you.
all the answers, and thank you to other people for the discussion. Fantastic.